and did not make it to the Senate floor. So we are back with this, what I feel like is a very important bill. The First Offender Act was put into place to give people who commit certain crimes as their first offense the opportunity to serve their sentence, and then upon successful completion, their records would be sealed. And the importance of that would be so that they could, having only committed the one offense and not having committed any other offenses, having a criminal record would not hinder them from seeking job, employment, housing, other things that you need to do to have a successful life. I think it's important that we're tough on crime, but that we also are compassionate to people, especially when they commit a crime but don't commit another one. The crimes that are excluded are of a particularly violent nature or sexual nature, or crimes against children, including pornography or providing graphic images to them. Those people are not eligible for the first offender plea, to use first offender, and this bill does not change that at all. All this bill does is say to the judge, you would seal the criminal records upon sentencing instead of what it currently is upon completion of the sentence. We feel that's important because everything's online now. And so everything can be found. And if that's the case, then once a person successfully completes their sentence, if all this information has already been found online, in effect, it's not their second chance, and it is not a clearing of their record. So a judge in this case would continue to reserve the right to not accept a first offender plea if he or she felt like that particular offender wouldn't be a good fit for that plea. And also, we made sure in this bill that the judge reserves the right to unseal those records at any point if he or she feels like that is appropriate. So we've made sure that we protected the right of our judges to use their discretion that we trust them to have. We have worked with several agencies and entities to make sure that they had access to these records even during the time that they're sealed if they needed them. That included GBI. Who else does this include? Financial institutions that need to access these records if they're hiring someone as required by federal law. They need to make sure that there aren't certain convictions. Pretty much anybody that came to us with a concern, we made sure we maintained the spirit of the bill, but made sure it worked for them. So that is it in a nutshell. I'll be happy to answer any questions. And I do want to make sure I disclose this to you. There was an amendment in Senate Judiciary Committee. It did not change the spirit of the bill, but it was more of an operational change. And Mr. Askew would be happy to explain that to y'all if y'all like to hear what that change was.
Sure. So, good morning, Wade Askew from Georgia Justice Project. So, as Chairman Hagan said, when the bill crossed over after being voted on unanimously in the House last year, we got to the Senate Judiciary, and there was one judge who very much agreed with the spirit of the bill and wanted to actually work with me on just some operational concerns of specifically making sure that, as Chairman Hagan said, when a record is sealed under law, there's a number of parties who are entitled to access to that sealed file, so law enforcement, judges, etc. He wanted to make sure that the process for being able to view that sealed file, particularly when someone is still serving their first offender sentence, was absolutely minimal, which we fully agreed with. And so what we did is I essentially co-wrote this bill with Judge Stevens in Glenn County to make sure that he was comfortable from an operational standpoint that everyone who needs that fast, easy access has it, and that there is there is literally written in now, there's a notice on top of the file that the clerk has to put on that says these parties are entitled to access with this, no need for a court order, no need for any process. So that's it's an operational change to make sure that we always want to make sure that what we're trying to do here works on the ground. And so that is the only change. The actual substance, everybody was happy with. And as Chairman Hagan said, last year this language was vetted by PACs, Superior Court judges, Superior Court clerks, the GBI, DCS. So a lot of folks have had their eyes on this.
All right, thank you. Leader of Strations got a question.
Thank you, Madam Chair. Just several quick questions, if that'd be okay. So Mr. Askew, just kind of, I guess, along the lines of what the judge and you were discussing, just operationally how this would work, just a couple things.
Mm-hmm.
As I recall this legislation, I guess it was back 2016 from the which would allow for records restriction or sealing at the time of sentencing of a first offender. There was discretion with the court as to whether or not to grant that, and we're taking away that discretion here by saying shall. This shall be sealed at the time of sentencing.
That's correct.
Okay.
So in 2016, we said that at discharge, it shall be restricted. And so what it is currently is that at sentencing, purely discretionary, both restriction and sealing. And I'll take a quick step back using those terms, restriction and sealing, which I know, Leader of Frustration, you're probably familiar with. Of restriction refers to limiting public access to the GCIC record. Sealing refers to court-level access to these records. We're somewhat unique in the state of Georgia that we have two court orders to handle those two different functions. And so what effectively happens is folks are told, hey, at discharge, this is restricted, and you'll be able to move forward. And so we often have clients who come in a decade plus later to say, I was told that this was restricted from public view, and it just popped up on my application to rent an apartment or get a job. What on earth happened? Someone made a mistake, and we have to explain, no, you got restriction, not sealing. Sealing in the real world, as Chairman Hagan explained, is what's actually effective in the age of the internet in private background checks. And so that the two change, essentially here we're just making two changes. One is to say we intended to restrict access to this records, but we're just not doing it effectively. And so we need to do both. And then, as Chairman Hagan said, let's move that from discharge. Right now it's the option at sentencing, but mandatory at discharge. Let's move it up to at sentencing, because really once that bell is rung, it can't be unrung in our current age. And so, of course, if someone gets their status revoked, we're public, right?
Yes, so obviously during the pendency of the case, prior to the court accepting the sentence and the disposition, I suppose, when this would occur, the fact that arrest was made, the charged offense, that is all public. I mean, that's available through the clerk's office or through the jail or things like that.
That's
so
right.
That potential harm of public access to that could follow a person for years is already there prior to sentencing. Is that right?
That's true.
Okay. And then also, I remember this very clearly. There was a balancing test that the court needed to consider at the time, which is the public's interest in access to this information versus the first offender probationer, because they can go to prison with the first offender.
Mm-hmm.
So the first offender defendant's disposition, and that balancing is being removed here in this bill. Is that right?
That's correct.
Okay. And so if you would just help me with a few quick hypotheticals here. So if I am it's a criminal offense in Georgia, I believe, to possess a firearm as a first offender probationer. Is that right?
That's
okay.
right.
So that's the existing law right now.
Right.
Right or wrong, that's the existing law. And so how would somebody know to report an offense if there is no means by which to know a person is a first offender probationer in order to report that crime?
So we actually have a specific line. That concern came up with, I think it was DCS who flagged it, if I'm remembering correctly. Apologies if it was GBI. Someone flagged it.
Mm-hmm.
They deserve the credit. Where we put in a line here specific to making sure that any firearm background check, any firearm related reason, you have access to these records.
That would only be, I suppose, a dealer or or law enforcement in practice.
I'll have to admit I'm not the most familiar with gun purchases and So I don't want to say definitively, but what I can say is that this concern came up from law enforcement entities. They proposed the language that they felt covered the concern, and we put that in there.
So what if I own an apartment building and I'm attempting to determine, you mentioned housing earlier,
Mhm.
and I think part of the weighting test was the availability of housing of a first offender probationer.
Mhm.
So how would if I owned an apartment building, I come to know, say aggravated assault is an available offense for first offender sentence, right?
Right.
Is that right? Okay. So if I've committed a drive-by shooting in the past and I have an aggravated assault first offender treatment that was accepted by the court, and I'm applying for housing at an apartment complex, how will the apartment complex landlord know of that prior disposition?
So they likely would not. I would say I would find it extremely unusual and unlikely that a drive-by shooting would get first offender treatment. Because again, first offenders categorically ineligible are serious violence, serious sexual offenses, and a number of others. And again, prosecution and judges have discretion on
Sure.
whether this please.
I can speak to a case that I previously prosecuted. It was a murder charge, which after I left the DA's office was reduced to manslaughter, and first offender was granted. So that can happen, in fact, right?
Mm-hmm. It's possible.
Okay. And then my final question, which is practicing attorneys are able to impeach witnesses based upon prior criminal history, right? With certain restrictions under the evidence code. Is that right?
That's right.
Okay. Is there any, how would a practicing attorney come to know of these prior criminal dispositions for use under our evidence code?
So I'm just double checking our list here. So we have specifics as in terms of prosecutors and public defenders and defense attorneys. In a civil case, the opposition party to someone under First Offender Act who's received First Offender Act sentence, not sure if we do have a specific write-in. If that were a specific concern for purposes of impeachment, to be able to check for that for an attorney in litigation, I think that's something we'd be open to.
Okay. Thank you.
Thank you. Any other questions? All right. We only had Wade Askew sign up. Anybody in the audience want to speak? I know we've got GBI. No? Yeah, of course. Robert Smith, come on up.
And I think to help Mr. Leader with your
And if you can just say your name and
Sorry.
where you-
Robert Smith with Prosecuting Attorneys Council, and we've worked with the Georgia Justice Project on this bill. They've taken a lot of our input, and I appreciate Wade and all of his hard work in this. To answer your question about access, that's one of the things that's built in. So when somebody if I need to have access, like if or law enforcement encounters someone, they're specifically allowed to have access to this under the terms of, I think it's line 172 to criminal justice agencies. On the housing question, that would be pursuant to what was it? The language as required by federal and state law, which is lines 183 through 185.
Madam Chair. Okay, so on line 172, it says to criminal justice agencies for an attorney. So how does an attorney in a civil case get the disposition for, is that
Well, and that's,
captured?
I don't think it is, and I think that's part of the problem we're having right now with our Supreme Court in use of that information, because it's not a conviction. So if you can't use it, if it's not a conviction, you're talking about conduct, and that's going to be subject to 404B.
Right.
And while I don't know civil law as well as you do, in my world, in the criminal world, our ability to use 404B is becoming so much lesser and lesser, and so much more difficult that I'm not sure if it impacts if the same rules are being applied to civil cases or not. but I know that in my world, it's pretty much impossible now to use 404B, unless it's it's become not just a similar transaction, but a exact transaction. The heightened standard that we're now under. So, yes, civil lawyers are not included in this list, but I wouldn't know how to use that because it's not a conviction. And there's been that language about nolo pleas as well not being able to be a disability. So if this is not a conviction, if you're basically just saying, well, on this day you did this act, I think there's a balancing, and that information may or may not be available. The rest would still be available. The disposition would not be.
Sure. Well, I will just speaking broadly here, I have expressed my concerns about this issue broadly to, I think, probably everybody who's sitting in the room, and I very much feel that under 24.6, I believe it's 609, 24.4, 404, that this is relevant information which we have in the evidence code already, should be accessible to parties in civil case, right or wrong, that's the law. And so, which I think mirrors the federal evidence code, or very close to it. And so I just think we need to carefully consider the implications of this. I have been a big proponent for criminal justice reform in certain areas in the past, but public access to information can be very important, particularly when by law we've said that access is something that juries should know and consider. So
I don't disagree. It becomes that whole notion of the three branches of government, and this branch tells us what the law is. The branch that interprets has interpreted your words to mean something that maybe not your intent.
mm-hmm.
Thank you.
Thank you.
Mr. Askew, I've got a quick question, and to the author of the bill. I understand the intention is obviously to help those defendants taking advantage of First Offender Act. Given the concerns that Leader F. Strachan has brought up, which made me think of this question, is do you see prosecutors or judges possibly limiting giving first offender base because of those concerns, and therefore basically going against what we're trying to do here and allowing First Offender Act to be used?
Right. I'm happy to start. So that's actually a direct conversation we had with Superior Court judges, and specifically with Judge Stevens, who I worked on in this bill. And his concern, the way it was initially written, because the operational concerns were exactly that, of him saying, I understand I have access to sealed records, but on the ground sometimes it's tough for us because not all clerks treat sealed records the same. And so I love the First Offender Act. I like the spirit of this bill. I'm concerned that judges will be shy because those operational concerns. And so we heard that and worked with him to alleviate those. In his perspective, once we got it in this state and he shared it, like I said, we went through kind of the official avenue with Superior Court judges, and then he also distributed it widely with that rewrite, especially with judges who had originally expressed similar concerns. And the feedback that we got at the end was, we're good. I'm no longer concerned that judges will be hesitant to grant based off of this. So obviously I can't speak for every judge in the state, and it's certainly possible, and I don't want to dismiss that, and it's something that even internally, transparently, we discussed. But through that feedback, through all the vetting, we have been encouraged of not thinking that would be the case, and also there's also just been the spirit of, if we're going to have it, it needs to really work for folks to have, that functional second chance. It was created 57 years ago to create.
Okay. Sure.
If I may, that was my reason for wanting to carry this bill, is that I want to make sure the spirit of the First Offender Act is intact. And multiple parties who have come and talked to us through this process, including in the interim since we passed it out of the House unanimously last year, was that the spirit of this law is no longer intact. And so I definitely understand the concerns of those of you that are completely more knowledgeable of the legal process than I am, that some judges may be hesitant to use it, but my concern is that right now it's not effective at all whether they use it or not. So that was my reason for wanting to carry this bill. And you know, as Mr. Askew said, we're perfectly happy to work with anybody who has concerns to make sure that we meet those concerns and address those concerns within the bill so that it works for everybody involved, and including the people who a judge sees fit to allow to plea first offender.
Thank you. Any other questions? Any discussion? All right. And again, we're looking at House Bill 162 LC 481348. Is that correct? All those in favor of passing House Bill 162, say aye. Oh, I'm sorry. I'm so sorry. I apologize. It's been a minute. Any motion? Second? Any second? Second. All those in favor of passing House Bill 162, say aye. All right. All those opposed? All right, it passes. Thank you. And hopefully we can work on some of those concerns that were brought up today. Thank you. Thank you.